So many questions are being posed to me as to whether they should wait for years together once they receive court summons, and what actually the course of action that they should take in the event their relatives or friends or some opposite opponents file cases against them. Whether civil or criminal, the procedure is simple. Once any case is filed against them and people are made to receive court summons, number one most important thing is that they need not stand to trial for years together. There is one option for them that through their advocates they can get the cases quashed immediately at first attempt itself. The moment you file one wakalat and appear in that case, your advocate will take care of that case. He has got options before him. Number one is, if it is a case of civil, Order 7, Rule 11. This is one provision laid down in Civil Procedure Code. According to this provision, one can question the registration of a civil suit or petition against them. If the cause of action is not there, or there are grounds, several grounds given. One is cause of action, second jurisdiction, then the locus standi, then third is provision, correct provision. Out of 6 or 7 grounds mentioned in Order 7, Rule 11, if you are able to pick up one suitable ground, you can immediately file a petition before court saying that the case is not maintainable because of this reason. For example, recently I have seen about 4 sisters have filed a suit against their brother seeking partition of properties. So, one agricultural land situated in Ramchandrapuram and a constructed building, Pakka building in Kukatpalli. They filed a partition suit and paid rupees 200 court fees when they are not in physical position. Immediately, the person, that is the brother against whom the partition suit came to be registered, he can file a petition under Order 7, Rule 11 saying that the petition is not maintainable for simple reason of insufficient court fees. That is all. First of all, it has to be decided whether the petition is maintainable or not. Once it is decided, it can be seen further whether the parties can proceed with the trial or not. So, this is one way of concluding the trial at the very beginning itself by invoking Order 7, Rule 11. Now, coming to criminal side, there are 2 options left to people. Suppose a case is registered against a person and court sends summons, accused summons to him. He can immediately file a petition under 245 CRPC, that is discharge petition. Pray the court that I need not stand to trial, therefore discharge me. He has to place sufficient grounds. Suppose the criminal court does not discharge him, other alternative left for him is approach High Court under under section 482 of CRPC. This 482 CRPC is a very elaborate relief the courts will give, and you try to establish that the opposite party has resorted to abuse of process of law. Once you establish this fact, your case will be struck off. Even if it is at the stage of FIR, we have Bhajan Lal's case, and hundreds of cases are being decided by various high courts and Supreme Courts. Also said that if there is no case at all, that is, after going through the contents of the complaint, if one comes to conclusion that there is no prima facie case made out, then persons need not stand to trial. Simply the criminal case will be quashed, and now people are rushing to high courts under this section 482 CRPC. Therefore, whether abuse is there or not, it is your duty to establish. This is how people need not worry, need not get afraid the moment they receive court summons. There are options available to them. Instead of standing for trial which will be after 4 or 5 years, they can straight away go to High Court and challenge the FIRs or challenge the charge sheets. They can get relief from the courts. And one more thing, in case of matrimonial matters, husbands are filing petitions against their wives under section 9 of Hindu Marriage Act. They want their wives back to them for reunion or for conjugal rights or cohabitation. In fact, he files a petition before court, family court, and wants his wife. But on the other hand, he goes to police station. When he is called for counseling, he says that he doesn't want his wife. So he takes two stands, one before court that he wants his wife, and other at the police station says he doesn't want his wife. Then in such cases, the option open to wife is straight away file a petition under Order 23, Rule 3. This petition, if wife files, and according to that Order 23, Rule 3, there are three options left to the wife. One, if there is a written agreement. Second, if the parties come for a compromise on certain terms and conditions. And three, if the wife is satisfied. If the wife is satisfied with the petition filed by husband, then she may go to court and simply file a petition. Simply file a petition under Order 23, Rule 3, saying that, yes, I am also ready to go and join my husband. Therefore, please decree the suit. The law laid down very clearly that the day when Order 23, Rule 3 petition is filed before courts, the courts cannot grant adjournment on any pretext, but simply they are bound to decree the suit on that very same day. This is the legal position, and recently I have seen in Anantapur where the husband wanted his wife, but he goes to police station and says that he doesn't want his wife. When he is taking such two stands, I have advised my client to go straight to the court and file a petition under Order 23, Rule 3, admitting the entire contents of the petition and plead before the court to pass a decree and judgment. But the courts have only adjourned the petition by 2 months. That is, in the last week of June, the date is case is adjourned to. The law is speaking something different. The courts have also to be very, very careful in such areas where the law has laid down clearly that on the same day the court has to, or court is bound to pronounce its decree and judgment. The court did not pronounce its decree and judgment, so again it is for the petitioner to move the High Court and bring it to the knowledge of High Court that the family court Anantapur has behaved in such and such fashion. This is how, when cases being filed against them, they can defend themselves under these three different styles. And also, other than this, we have luckily several agencies which are now trying to bring reunion, bring conciliation between the parties, alternative disputes redressal system we have, and using this system, now even special agencies have come down. With the help of all these special agencies, now at least some pendency before the courts is reduced, and this is one good development in the court system.